Welcome to Chapter 3. We're implementing equal employment opportunity will be the discussion for today out of our Human Resource Management textbook. Make sure that you take good notes, as you should be able to see by now how the assignments and the quizzes are laid out. You can get a better feel for how future exams will be. I do switch it up a little when it comes to the exams. They're more in depth, but it's important that you're able to not just recite information, but you learn it. It's embedded within you. For those of you that have a desire to be HR professionals, it's important that this information it becomes part of you. For those of you who have an interest in management or owning your own business, you need to know this information. Even though you will ultimately not be involved in the day-to-day of this, but initially you will. As a small business owner, when you first start out, you will be wearing all of the hats because you cannot afford to pay all of these different wages to people or even to outsource it to companies in those early moments of your business. So you need to understand this information so that you can do what's best for your employees, for your company, and of course for the community that you serve. So with that, let's discuss how we can implement an equal employment opportunity. So here are some of the learning objectives. These are the things that you should know by the time you're done reading this chapter. You should be able to explain the role of the Employer Information Report, which is an EEO1, define employment parity, occupational parity, systemic discrimination, underutilization, and concentration. You should be able to describe an affirmative action plan and be able to define a bona fide occupational qualification, which is a BFOQ. You'll be able to explain what business necessity means, define sexual harassment, and describe the comparable worth theory. So let's look at the legal powers of the EEOC. They're authorized to develop and publish procedural regulations regarding how we enforce civil rights laws. And it's issued some substantive regulations where we can then interpret Title VII and the ADA and the Equal Pay Act, as well as the Civil Rights Act of 1991 and others. It holds enforcement authority to be able to pull the trigger, no pun intended, on litigation, right? So on lawsuits, and to help intervene when there are private lawsuits, so when they're not necessarily made public. There are various posting requirements that employers must abide by. And so Title VII requires that employers, employment agencies, and even labor organizations have to post EEOC prepared notices somewhere on the premises, preferably where employees can actually read those notices. And you'll read further in the text where you can see, like I said earlier, some of the various requirements of Title VII, the Equal Pay Act, Civil Rights Act of 1991. And you can see which organizations by Executive Order 11246 have to display these. So there is a standard Form 100, which is the Employer Information Report, that any employer that has 100 or more employees are required to file with the EEOC. It's amazing. You'll hear people in there, because they don't know, because they're not well informed, they'll hear certain things in the media, and I'm not just talking about these kind of reports, but just in general, you'll hear certain things in the media that's dealing with large corporations. And there's less than 1,000 large corporations that employ 10,000 or more employees. But you'll have someone who has 50 employees who thinks that they are somehow bound by the same rules, regulations, and laws that the larger corporations are. And so really it's really important to understand what applies to your organization, to your industry, and that way you don't get caught up in nonsense, as well as you don't get blindsided when you are supposed to file something or you're supposed to um, report on something and you don't. So with the standard Form 100, it requires employees to break down their workforce into specific categories by sex and national origin and race. That way, the EEOC sees how many people in all of these different categories that you actually have in your employment. It will also help with if there's a case of discrimination, that they're able to look and say, wow, you have 100 African Americans, you have one Asian American, you have no Latin Americans. Why is that, right? Or you have 100 men and 2 women. Different things of that nature. Or you're only hiring the people that were born in the United States, but you refuse to hire people from another country. So this helps with things of that nature. Just make sure it's not quotas. It is making sure that there is diversity, that you're not discriminating, that you're not only selecting a certain group of people in your company where there's then bias and discrimination, things of that nature. And you'll notice that there's similar forms that are also required for school districts, different educational institutions, unions, and committees that are both have a joint labor management. So that could there's different forms that are similar that can then help in those areas as well. Now, Title VII also requires that certain covered organizations have to maintain records that relate to the applicants that apply for jobs, the payroll records, any transfers, recalls, as well as discharges. All right, so discharges is your termination. And this helps to determine whether unlawful employment practices have been committed. If you have people that have been applying for jobs and you're not hiring them because of whatever reason, their gender, their sexual orientation, whatever the case may be, if you have kept adequate records of those applicants, then we're able to then check and see your payroll records, things of that nature, they're able to then be able to have a stronger case against you or not. And so the EEOC allows organizations to use an applicant diversity chart for collecting data on protected groups. And like I said, it's not a quota, it's just where you're able to look to see, are we really representing the global perspective? Are we really representing the various customers that we have that we want? Are we representing all of the children of the world? And at best, if we could, if possible. And if you're not, if you notice that you really are only representing, a very small population, then you are clearly not a diverse organization. So there's a process when you deal with compliance, and discrimination charges can be filed at any EEOC office or with any EEOC representative. And there's various methods that are used to determine whether or not there's discrimination against a protected group of people. We have different parities that we look at, and There is the employment parity that looks at the number of minorities and women that are employed by an organization and whether or not that equals the number of organizations within the labor market, right? Within your industry. How many women and minorities do you have within your organization compared to all the other organizations within your labor market? So if it's construction and you have 50 women and 45 African American men and 75 white men and whatever the numbers are, and they look at other organizations within that same market and say, how do you stack up? When we deal with the parity concerning the occupation, is looking at the proportion of women and minorities that are employed in different occupations within an organization and seeing if whether or not it's equal to that proportion within the market, right? Within that same industry. So if you notice the difference, right? One is dealing with the who's employed, and the other is dealing with the actual occupation, what your job title is, what you're doing within the company. Are they only giving menial jobs to minorities and women, for instance? That would be your occupational parity. Then we have what's called systemic discrimination. And that's where you're seeing either in the occupational or employment parity a huge difference, right? Where it is just blatantly obvious that you're discriminating against women and minorities, you're the protected groups. And that's when you have systemic discrimination. And then with our relevant labor market, that's when you're looking at a geographical area where you're doing your recruiting, right? So if you're focusing your recruiting in a predominantly white community, then of course there's going to be a lack of diversity in that market, in that geographical area. And so those things are taken into consideration. So the EEOC can examine the underutilization, so that you're not fully involved in, right? You're not fully endorsing, you're not fully recruiting and hiring to an adequate level. The underutilization or the concentration of females and minorities. So it can be you can have a large amount or you're not. So they're able to examine those two. And underutilization is where you're having fewer females or minorities in a particular job category compared to their presence in the labor market. So if you have 100 women in the labor market, but for whatever reason, you're only having 5 in a specific job category, when actually the market is showing that there's women in various roles within that market, that is underutilization, for instance. Concentration is when you're practicing having more women or minorities in a specific job category compared to their presence in that market. You're concentrating them only in jobs that, like for instance, that will have a lower likelihood of promotion into an executive role, for instance, or a position that will not put them in not provide them an opportunity to have a salary, for instance. That is what can be considered as concentration. In the past, which is still current today, you'll see where some groups, protected groups, are being concentrated towards janitorial, things of that nature, where your ability to go up the corporate ladder is basically not going to happen, right? You're being limited and concentrated in this one particular area, and someone can check the box and say, well, I gave them a job, but you're not when you look at the labor market, you're really not utilizing them the way they could be. So there's a right to sue letter, and there's a notice that's a statutory notice that the EEOC provides to the person who's the charging party, right? That's the person who plans on bringing charges against the organization. That if the EEOC does not decide to file a lawsuit on behalf of them, there's this statutory notice. The charging party has to file their civil action, their lawsuit, in the appropriate court within 90 days after receiving the notice. All right? So if you don't file your action within 90 days, guess what happens? It's bureaucracy. There's a bunch of red tape. It's gonna get kicked out, right? The likelihood of it not getting kicked out is very slim. So it's basically saying you have the right to sue, but we're not going to pursue the suit on your behalf. So Table 3.1 shows you the steps in how to process the discrimination charge. And there's the step numbers and the procedures. Of course, you see step 1 is the charge is filed with the EEOC. And then after the EEOC evaluates it and determines whether or not to proceed, then they decide to proceed with the charge. They'll serve you with the person with a copy of the actual charge. There's a face-to-face. There's some fact-finding, mediation. If it's not resolved in the mediation level, then there's an investigation of the charges. And then when there's reasonable cause that discrimination has occurred, then there's an agreement that is set up between the parties, and the respondent has to agree to that or not. And if the respondent chooses not to agree with this conciliation agreement, then the EEOC will make a determination on whether or not the charge is litigation worthy, whether or not it's worth going full steam ahead for a lawsuit. And if it's litigation worthy, that means there's going to be evidence that's going to be gathered around that investigation to support a lawsuit. If then at that point, the EEOC will file a lawsuit in the appropriate state or federal court. And from there, the decisions in these lower courts are oftentimes appealed to the Supreme Court. Why? Because you'll have the organization saying, no, I don't agree, blah, blah, blah. And they'll go and appeal to the higher court, which is the Supreme Court. So here's the 8 steps. Of course, many people would love to have the charges resolved by step 4. And a lot of times it's not. And so it just happens that way. Now with AAPs, those are affirmative action plans. It's a written document that outlines specific goals and timetables to remedy any past discrimination actions that were against an organization. And all U.S. government agencies have to prepare an AAP. Right? So you're looking at, we've had this issue in the past. How are we going to remedy this so that we don't have this issue now and in the future? And these are the specific goals that we have. And here's the timetable in which that we want to reach these goals. Why is there a timetable? Because without a date attached is not a goal. It's simply a dream. It's a wish upon a star. You have to have a date attached to that. So a BFOQ, some people may also call it a BFOC. But BFOQ is the bona fide occupational qualification. That's where it allows an employer to use religion, age, sex, or national origin as a factor in employment practices when it's reasonably necessary to normal operation of the business. And so there's you can it's a guaranteed. It's I'm not discriminating. But I need these specific things in order to operate this organization. You'll read further in the textbook where it goes into more elaborate detail about the BFOQ. And you can then contemplate how someone could still manipulate this, and people have tried to manipulate it, and they get the big no, because they're trying to say, well, this is why we can only have men in this role, or why we can't have senior citizens. I mean, we can clearly see why a certain job would require you to be of drinking age or driving age. Let's say that all of the jobs require you to have a driver's license. Well, if you're 14 and your state does not allow 14-year-olds to have driver's license, well, then that's a great reason why you cannot hire 14-year-olds, for instance. All right. And the same would be true if you lost your license for whatever reason, because and somehow age was a factor in there, then that could be excluded. Religion can be used if the organization is of a certain religion and the products are based on a certain religion. A organization could possibly use religion as a factor. So with that, there's exceptions that are raised by employers, and here's some of the exceptions: your ability to perform a task, same-sex BFOQ relating to accommodating personal privacy of your clients and customers. And then, of course, there's a customer preference where the customer states a desire to be served only by a person of a given sex. So you can have that: I don't want a man to do whatever the thing may be, and it could be I don't want a man to be my gynecologist, right? And so different things like that, where I want to have it where it is same sex. Now, based on these exceptions, courts have, of course, narrowly interpreted the sex discrimination defenses. They've held that each individual job applicant should be permitted an opportunity to demonstrate ability to perform. They've rejected customer preference as a BFOQ defense and used age as a BFOQ in certain limited situations. All right. So you can't discriminate against a 50-year-old just because you're 20 and you only want to see a bunch of 20-year-olds in your organization. So now when it comes to business necessity, this applies when you have a job criterion. You have a set description for your this job, and it's neutral, right? But it excludes members of one sex at a higher rate than members of the opposite sex. So it excludes men, I'll say, for no specific, or it could be a specific reason. And it could be, I don't know, it's a lingerie shop or whatever, right? But whatever you come up with, and for that, your job criterion excludes the males at a higher a higher rate than women, or vice versa. Focus is when the validity of your stated job specifications, where you're saying this is what's required to do this job, that the validity of these specifications and their relationship to the work being performed. The focus is zooming in on that. Is, okay, the work being performed, how much is that aligned to what you're saying the job is supposed to be doing? And if some of you have ever noticed that, where you know that someone has a certain job title, and then you look and you're like, well, what do they really do? Have you ever looked around your company and wondered what some people really do? Or even within the role within your company, you probably had a job description and probably have a breakdown of different things, and you realize that you're actually performing work that maybe covers some of that description, but it doesn't really encompass all of it. And so where's the focus of that job? So you'll read further on that, and it helps you really, I'm going to go back. It helps you to really understand the importance of being specific in the fact that those jobs that human resources works with senior managers to design, to describe, to define, that employees need to be doing 80% or more of that job as defined. If you have a job description and there are certain specifications for that job, and you're only doing 30% of that, then you're not doing the job. You're doing something else. You're doing a modified job, and at that point, there needs to be a different job description attached to that. And that's a lot of times how people get themselves at the EEOC's office really quick, because I was hired to do this job and I'm not doing this job, but they have me doing this job over here. And I could be now doing something menial compared to what I'm supposed to be doing. Or on the flip side, I have this job description, narrow is defined right here. It's very narrow in scope. But they have given me this extreme workload over here. Well, in that case, that is more aligned with this other job title, which actually pays 30% more. And I've brought this to my employer, and they refuse to either A, redesign my job, or B, give me the promotion and raise. Or just give me the raise. You don't have to give me the title if you don't want to. And so that's where it's really important that you're looking at these things. So we talk about sexual harassment, and this is really important because a lot of people don't really understand sexual harassment. They are thinking that it has to be some guy panting heavily in a woman's ear, speaking inappropriately, and that's not necessarily true. It's anytime you're creating a offensive, hostile, or intimidating workplace where there's some unwelcome sexual conduct that is interfering somehow with another person's work performance. And guess what? It doesn't have to be that you are actually harassing me directly. It can be that I'm a bystander and I'm just sick and tired of being sick and tired of your behavior. And it can be things from inappropriate text messages, emails, passing along of photos, magazines, books, pictures. I already said photos. It can be jokes. It can be videos. You could be playing back a YouTube video. Different things of that nature. If I am within earshot or I can see it and I am offended by it and it's interfering with my ability to do my job because I'm not focused on it, that is sexual harassment. And so it's important that organizations spend the time, invest the time in their employees and in the ecosystem of their organization to build a culture that is 100% against sexual harassment. And it's not just of men towards women, but also women towards men, women towards women, and men towards men. Right? It hits all genders. And when deciding to impose a liability, right, on an employer, courts have considered the failure to investigate complaints as significant, right? It is looking at the failure of an organization to do their due diligence to go and do proper investigation of all parties involved. If I heard it and my desk is only 3 feet away from this other person's desk, then that means that everyone else within that approximate space also heard or saw what I heard and saw. And so the employer must do their part to do extensive investigation. Because if not, if you only get one limb, but the other limb is also infected, well, okay, you remove that one person. Well, if there's also another culprit involved, that other person most likely is not going to stop because they felt that they didn't get caught. So they'll just wait and try again another time. What's also important is that a lot of people by nature don't think that women can be the harassers in a scenario such as this. So you become dismissive of claims of complaints about a woman sexually harassing a person. You're like, oh, and what happens is you fall into the trap, especially if you're a guy, of saying, ooh, a little girl on girl action. Wrong. That is that is offensive in itself and falls right into the sexual harassment checkbox. So it is understanding that all genders can create an intimidating, hostile, or offensive work environment for all genders and can have unwelcome sexual conduct displayed against the same gender or opposite gender. And so it's really important. And so the nature of sexual harassment can sometimes make it very difficult to prove because people don't really understand the depth and breadth of sexual harassment. So an organization's policy on this should define and prohibit sexual harassment. There should be a zero tolerance of it within your organization, and it should encourage any employee who believes that he or she has been a victim to express those complaints to management, right? It should be clearly defined. There should be no gray area. And it should be something that your organization is consistently training on so that you don't have any instances of gaps where your employees are ever they're not in the know, right? They like you've gone 2 years and you haven't had a training on it. It needs to be something that becomes embedded within the culture of your organization. Now, comparable worth theory. Here's the idea behind this, is that every job has a worth to both the employer and to society as a whole. And that worth can be measured and a value can be assigned to it. There is worth, there is value in each and every job within an organization. There's value to you as the employer. There's value to society as a whole. Because if there's a product being developed, each person that plays a role in that product benefits society. Hence, it benefits the employer, right? Every time that product is purchased, the employer benefits. So it can be measured and a value can be assigned to it. So each job should be compensated based on its value and it should be paid the same as other jobs with the same value. Here's where organizations, where people that are coming up with how they're going to pay for a job, this is where they drop the ball, because oftentimes they place less of a value the further you are away from the top of the organization, right? So you have your CEO who gets this great big check, but does that CEO have the same value worth measured by society? If the person who's actually doing the work gets paid considerably less, and society is looking at the craftsmanship of a product, the crafter is who society is valuing. They're saying, look at the workmanship, look at what was done, look how beautiful it is. It's flawless. Well, that's not the CEO's doing. No offense to the CEO, but that's not the CEO's doing. The CEO didn't come down there and craft this masterpiece. The designer that put their hands on it, they are the ones who did it. That's who society is reveling over. So shouldn't they then get compensated based on that? And that's where you have this divide, this big issue. But of course, that is on a much larger scale, right? And of course, we're not going to see that happen. But you also have a case where, when we're dealing with sex discrimination cases, and we have Title VII of the Civil Rights Act, we have where there's entire classes of jobs that are traditionally undervalued and underpaid because they are held by women, right? And with that, women could be doing jobs that have greater worth and that are paid more, but because they are women, they're not getting those jobs. The same can be true of certain groups of people of color, based on the historical value that's been placed upon them. That would include African Americans. That would include Mexican Americans and other Latin Americans. That would include our Native Americans, based on the value system that's placed on them. So looking at that comparable worth theory is key. And until we can start compensating based on value to society first, right? Not based on the value of the person, but based on the value of what you receive in that service or that product. If society could not tell whether or not it was a man or a woman, whether or not the person was black or white, they just could rate based on the quality of what they received. If that job was then compensated accordingly, we'd all have an amazing and fair living wage, right? The middle class would not feel like the working class, and the working class would not feel like they are in the deepest depths of poverty. And those that are in the deepest depths of poverty wouldn't be in the deepest depths of poverty, right? The ship would rise, because the waves would come up, the water would raise up, and you would have people that are actually coming up the ladder economically, if we actually placed a higher value on the job being performed and taking out race and gender and religion. So when we look at equal pay issues, Comparable worth theory argues that Equal Pay Act offers less protection to female workers. And wage discrimination occurs when women with education and ability and training equivalent to men are assigned lower paying jobs. And this happens quite a bit, where you can actually have more training, more education, and you're more capable of doing a job, and you're getting paid less. And you could be equal right there with them, and having the same degree level, the same amount of training, the same capabilities, and you're getting paid less simply because you're a woman. So how can an organization guard against this? And what employers should do is attempt to avoid overconcentrations of men or women. Don't try so desperately to, or not even trying to, just paying close attention to your hiring practices, that you're not overcompensating, right? So that you're having a healthy balance. Evaluating whether you have any direct evidence of bias in how you set your wages. Who is determining the wages? And is this coming from a biased or non-biased approach? How often are you changing it up? How often are you reviewing it and you're looking at it from a different lens? And of course, avoiding deviating from a set internal job evaluation survey or a market survey, right? If you've got a set evaluation survey that you use internally, don't try to start deviating from it. Stick to it. Use it, unless it's just a total, junk survey that you just pulled out of the air. But if it's a strong survey, use it, because that'll help you keep things aligned, especially with not only the marketplace, but just within what you said you want your core and your ecosystem of your organization to be. You should constantly monitor any type of job evaluation systems that you have to determine if the average wages being paid to men and women for comparable jobs are complementary. And if not, then that's how you're able to make those modifications. If you're noticing that your women are consistently being paid less for doing the same job, then guess what? You need to make changes in that pay structure. There's other areas of employment discrimination. Of course, I touched on these earlier. Native Americans are highly discriminated against. People of different religions right now, our Muslim brothers and sisters are under attack by anyone and everyone. And 90% of people don't even know why they're doing it. Those that are HIV positive with their status, whether they come out about it or it's found out, and oftentimes it is something that is inadvertently discovered through insurance paperwork, through HR, and it leaks out. Or somehow you had medicine and it fell out of your bag or whatever. Things like that come out. Sexual orientation. You guys are I know that you're not ignorant to this fact. The sexual orientation is a huge area of employment discrimination. Some people don't even get hired because it's either clearly obvious or it becomes obvious at some point during the interview that that person's sexual orientation is different or not aligned with the interviewers. So it could not even necessarily be the practice of the organization. It could simply be the person who is doing the interview, who does not like lesbians, gays, bisexuals, transgender, and could just say, application denied. And it could not necessarily be like I said, the practice of the organization. But guess what happens? The organization can come under fire because of the bias of that um, individual. So with that, this covers this chapter. If you guys take the time, really learn this information, you'll be able to identify within your own organization how well your company is reflecting the marketplace, is reflecting the needs and desires of society as a whole, not just an isolated group of people. And it helps you to see how you can build and transform your own company in the future, right? Don't practice bad habits. So if you're in a company that is wishy-washy, or they're inconsistent, or they're just blatantly ignorant, then don't turn around and practice those same behaviors when you have your own organization. So with that, have a wonderful day. And if you have any questions, please email me. Thank you.